Okay. Jeremy Keller,
Yes.
Jerome Walker, and Russ Bull Amilcar?
Yes.
Those are the only three?
They move up, yeah. And the only other rest is Spanish and she got married.
Okay.
So I didn't know if you wanted to don't want, but I did.
Oh, no, I do. I do. You can just leave them right there and I'll tell you when I need, if I need them. So I have.
Spanish.
Cherizal and Walker. Okay, let's just do them because I'm ready on those. All right, okay, I got it. And that's gonna be the Spanish, right? Okay, so that'll be next.
Yes.
All right, let me make sure we are on the record. This is, our morning session of initial appearances. I'm Judge Allen, counsel for state, announce your presence, counsel for defense, announce your presence.
Brenda Eugene on behalf of the State Attorney's Office.
Thank you.
Letitia George on behalf of the Office of the Public Defender.
Thank you. And we have Jeremy Joseph Keller. Mr. Keller? I am appointing the public defender in all cases unless the public defender informs me of a valid reason why they should not be appointed. All right, Mr. Keller, in your case, sir, I do find probable cause for your charge of trespass and set a bond of $500. I'm ordering that you not return to the location where this incident occurred and have no contact.
$500. I'll do my time.
$500?
I don't have $500. I'll do my time.
Okay. I did appoint the public defender. They have not indicated that they want to accept a plea in your case, so we're just going to just leave it at the bond of $500. All
Thank you, Your Honor. There's mental health issues.
right, $500. $500, sir.
Get out?
Yes, sir.
Well, then I don't have $500, but I'll.
Your excuse. I'm going to excuse you at this time, but, and leave it to the public defender to let us know if there are any additional matters that need to be addressed to the court, okay? No contact. Mallory Cherizal. Ms. Cherizal, in your case, I do find probable cause for the offense of battery. Is this a witness on the Cherizal case?
I'm sorry?
All right. Are there two witnesses, or what do we have here? So would you both raise your right hands to be sworn in, and then we need to have your names.
You solemnly swear affirm the testimony shall give me the truth, the whole truth, and nothing but the truth?
Yes.
Both state your name for the record, please.
Stephanie Adam.
All right, ma'am, listen, I'm going to have to ask that you really, really kind of project. I know you're having a little emotional moment, but I won't be able to hear you if you don't project a little bit more. I'm a little hard of hearing, so I need you to project, okay? So can you give me your name again?
Stephanie Adam.
Did you say Adams?
No plural. Adam.
Okay. Do you speak English?
Yes.
Okay. I'm still not sure I got your name, but let's go, sir. What's yours?
Charles Smith?
Mr. Smith?
Yes.
Okay. And are you and she, what's your relationship?
I'm just friends with Mallory.
You're friends. And ma'am, what's your relationship?
I'm her mother.
Okay. So, Mr. Smith,
Yes, ma'am.
are you a witness or are you just here for moral
I'm just
support?
here for moral support.
Okay, so we're not going to ask you any questions then. You can still stay there, but we're not going to ask you any questions. Ma'am, you're a witness, right?
Yes.
So we're going to ask our questions of you. The state and the defense may have questions, And I do need you to project into this microphone so I can hear you and not ask you to repeat yourself over and over again, okay?
Okay.
All right, very well. State Defense?
Good morning, ma'am.
Good morning.
To confirm, you are the mother of the defendant?
Yes.
Do you live together?
Yes, yeah.
While this case is pending, would you like to continue living together? Let me ask it another way. Do you want to have contact with her?
Yes.
Okay. Are you afraid of her?
No.
Were drugs or alcohol involved in this incident?
I think so. I'm not sure.
Do you know which one it would be?
I can't say.
But you do believe she was under the influence of something?
I think so.
Okay. Has something like this happened before?
Yes. When she was a minor.
Okay. All right. I have no further questions at this time, Your Honor.
All right, thank you. And Defense, I have appointed the public defender. Do you have any questions?
No questions, Your Honor.
All right, okay. I have found probable cause for the offense of battery. What says the state with regard to contact? I'm not clear.
I would have no objection. I would have no objection to contact, Your Honor.
All right, the court will order no hostile contact with the victim. I will further order a bond of $500 or PTR, for which you do qualify. Conditions are the same for either the bond or the PTR, no hostile contact. Possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. All right, thank you very much. Thank you, ma'am, and thank you, sir. Antonio Jerron Walker. Am I missing one of the pages for Mr. Walker on this?
No, Your Honor,
It's-
it's an
Oh, okay, I see it. All right, Mr. Walker. The court, oh, wait a minute. No, this is the one. Oops, so. Okay, this is not good, because I don't have probable cause. Yeah, it's not. Madam Prosecutor, were you given any information other than the 2014 CF 7086AO paperwork?
No, Your Honor.
Neither was I, and this is not sufficient for the court. I actually need to know what the underlying allegation is of the violation. I don't have anything.
A moment, Your Honor.
Do you want me to reschedule it for tomorrow?
Yes, Your Honor.
Okay. All right, sir, I do need more information in your case, and so I'm going to roll your case for 24 hours to give the state an opportunity to provide me with the additional information. I have appointed the public defender to represent you in your case. Thank you. All right, now, you can take these. Now, Spanish? Okay. And then, how many Spanish? All out of county. So the first one I have is Amilcar. Elasma. Andre Suarez Lopez. Okay. And that's the Spanish. Okay, let me just get to them. Amilcar. No, that wasn't on my list. I don't have Amilcar. No, wait, let's see. Cordes Castellanos. Is everything in that, when you go into it on the computer, is everything in there or some stuff missing? In that queue, cause I didn't see Elmo Carr. What all? Is this all the Spanish? Okay. Got it. Keep them all, just in case. So Elmo Carr is not in my list. Cuartos Castellanos. Not on my list. Oscar Londorio Rubiano. Londorio. No. And last but not least, Nunez Suarez. And that is also a no. Okay, we're gonna have to get to the bottom of this because I went into the queue and I went through a bunch of cases and none of these cases were on there. Well, somebody's gonna have to tell me that because I'm not gonna be able to know that without someone telling me. Because I went into the queue for initial appearances. And I read every single thing that was in there. But obviously, there's... Mm-hmm. So is that every day they scan a different queue for the outer county? So every day. So I'll have another queue I need to look in for the outer county. So we'll talk about that afterwards, but I'll just go ahead and go through these right now. Okay. Oh, wait, let me just go through these first. I haven't even looked at them yet. Is this just a duplicate? Okay. Mm-hmm. I'm gonna let you show it to me again afterwards. I did good because I was able to find the main list, and I did that pretty much by myself. I only had to call Juanita one time. And then when I got it, I said, "Oh, I'm so great! I did it all by myself."
You did wonderful, too.
But Juanita's on the phone, and she's like, and I'm like, "With your help." But you can show me.
Okay.
Let me just quickly look at these last three,
Okay.
because they are all pretty much straight, cut and dried out of county. Straightforward, not too much here. Oh, I'm just confirming these warrants. And they all have duplicates. You gave me a duplicate for all of them, okay. All right, now let's confirm. Okay, now the Creole I did read, that one's, because Ulusma, right? Yeah, that one was in the system. County, and then these are 1, 2, 3, no bond, no bond, no bond. 1, 2, 3, no bond, no bond, no bond. And this out of county, Suarez Lopez. One, two, three, no bond, no bond, no bond. And we can do the Creole after we do the Spanish.
Good morning, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
Good morning. We have several cases. I'm going to go ahead on and give you the names and case numbers. Actually, I'm not sure I have the case numbers. Where's the case number? Is it on here? Okay. These are all out of county, so we don't have case numbers. All right. Rosbel Amilcar,
Your Honor, if you could kindly spell that name of the defendant for the benefit of the interpreter, please.
first name Rusbel, last name Amilcar.
Thank you very much, Your Honor. Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
All right, Mr. Amilcar, sir, you were picked up on an out-of-county warrant from Sarasota County, Florida. Bond will stay set at no bond on each of your 3 counts: grand theft, residential burglary, and possession of burglary tools. I have appointed the public defender to represent you in this case.
Immigration hold.
Okay. Yeah.
Additionally, sir, you do have an immigration hold. Next case, Juan Camille Cuartas Castellanos. Cuartas Castellanos.
Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
Thank you. Mr. Cuartas Castellanos, you were picked up on an out-of-county warrant from Sarasota County, Florida. Bond will stay at no bond on each of 3 counts: grand theft over $100,000, residential burglary with property damage in excess of $1,000, and possession of burglary tools. You do also have an immigration hold, sir, and I have appointed the public defender to represent you in this case.
Your Honor, my apologies. Could you kindly spell that first last name? I got Castellanos. I apologize. I couldn't understand the first name.
Sure, Cuartas.
Thank you very much, Your Honor.
The next case, Oscar Daniel Landano Rubiano. Landano Rubiano.
Thank you, Your Honor. Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
Mr. Landano Rubiano, sir, you were picked up on an out-of-county warrant from Sarasota, Florida. The court is ordering the bond to stay at no bond on each of 3 counts on your out-of-county warrant for grand theft over $1,000 and possession of burglary tools, 2 counts. You do have an immigration hold, and I have appointed the public defender in your case. Thank you, sir. The last case, or next case, I should say, is Jefferson Javier Nunez Suarez. Mr.
Your Honor, the interpreter can confirm this defendant is able to hear through the
Thank
headsets.
you. Mr. Nunez Suarez, you were picked up on an out-of-county warrant from Sarasota County, Florida. The bond will stay set at no bond for each of 3 counts: grand theft over $100,000, residential burglary with property damage in excess of $1,000, and possession of burglary tools. Further, sir, you do have an immigration hold, and I have appointed the public defender to represent you in this case. Thank you. And the next case is Andres Felipe Suarez Lopez.
Thank you, Your Honor. Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
Thank you. Mr. Suarez Lopez, sir, you were picked up on an out-of-county warrant from Sarasota County, Florida. The bond will stay set at no bond for each of 3 counts. Count 1, grand theft, residential burglary. Count 2, possession of burglary tools. Count 3, possession of burglary tools. You additionally do have an immigration hold, and sir, I have appointed the public defender in this case. Thank you, sir. All right, does that conclude the Spanish? Mr. Interpreter, that concludes the Spanish cases. Thank you.
Thank you, Your Honor. Have a good morning.
You do the same. Okay, now, calling that other interpreter.
Welcome to an Acano meeting. You are entering the meeting now.
This is Judge Allen. Is the Creole interpreter available?
Yes, good morning.
Good morning. Could you introduce yourself for me?
This is Isabel DeRocher.
How are you doing, Mr. Rocher?
I'm good, Judge. How about you?
Doing awesome. Listen, have you been sworn in yet this morning?
I have not.
Okay, we're going to swear you in.
Okay.
Raise your right hand. Do you solemnly swear to translate from English to Creole, from Creole to English, in the testimony given today?
I do. Isabel DeRocher, Court Interpreter, Creole.
All right, let's swear in the defendant. Ma'am, raise your right hand to be sworn in.
Madame, levez mes doigts tout pour prêter serment.
Do you solemnly swear from the testimony you shall give be the truth, the whole truth, and nothing but the truth?
Est-ce que vous sermentez que témoignage ou bail la vérité, toute la vérité, rien que la vérité?
Oui.
Yes.
Are you Josemini Ilozma?
Vous mettez baisser main.
Oui.
What is the name, Your Honor?
Josemini Ilozma.
Okay. Est-ce que ou c'est Josmine Elusma?
Oui.
Yes.
All right, ma'am, the court finds probable cause in your case for battery domestic violence.
Juge la joine que gen assez évidence dans cas pour violence domestique et attaque.
In your case, I am ordering a bond of $500.
Juge la ap mette on bond en caution de $500 dans cas.
Conditions of bond are that you have no contact with the victim and that you not return to the location where this incident occurred.
Il dit ou pas capable gen contact avec victime là ou pas capable retourner côté bagay là supposément arrivé.
You are authorized to go back one time in the presence of law enforcement to recover personal items.
Ou capable retourner dans cas là en grande fois avec la police pour capable prendre affaire.
I am ordering that you possess no firearms and no weapons.
Ou pas capable gen aucun arme à feu ou pas capable gen aucun arme.
You must surrender any firearms or weapons to law enforcement within 24 hours of release.
Après que vous fin relâché, ou gen 24 heures pour bay toutes armes que vous ta capable gagner by la police.
I have appointed the public defender to represent you in this case.
Ou gen défenseur public qui pour représenter ou dans cas ça.
Oui.
Thank you, ma'am.
Merci madame.
Thank you, Mr. DeRocher.
Thank you, Judge. Bye-bye.
Bye.
You are the only participant.
Force me to learn it. Okay, let me turn this thing off.
You just come off, oh, we off, right?
I did.
Yeah, okay.
You wanna turn it off, please? Why is that still up there?
I just hit the, turn the button off right here.
Were we expecting any attorneys?
Well, you know, just, no, I don't think so, so, but
Okay,
just leave it.
all right. So now we're gonna go back in order.
Yes, now we,
Thomas Blunt.
Yes, ma'am.
All right, Mr. Blunt, the court, hmm. Can I see that paperwork? Oh, I got it. Huh. Mr. Blunt, the court does find probable cause in your new law violation for the charge of battery. And I'll set a bond of $500, order of no contact, order
Your
that you
Honor?
not.
There's a victim.
Oh, I'm sorry. Ma'am, raise your right hand. We're gonna swear you in for testimony.
you solemnly swear affirm the testimony shall give you the truth, the whole truth, and nothing but the truth?
Yes.
State your name for the record, please.
Jennifer Banks.
All right, Miss, did you say Baines?
Banks.
Banks, Miss
B-A-N-K-S.
Banks, thanks. The lawyers may have questions of you. Please answer out loud any questions that are asked of you.
Okay.
Good morning, Ms. Banks. How do you know the defendant?
He is my fiance.
Do you live together?
Yes.
While this case is pending, do you want to continue living together?
I like the other way you asked.
Do you want to have contact with him?
Yes.
Okay. Has something like this happened before?
No.
Were drugs or alcohol involved in this incident?
Yes.
Can you tell which one?
Alcohol,
Okay.
quite a bit.
I have no further questions at this time, Your Honor. Thank you.
Defense?
No questions, Your Honor.
All right. Mr. Blunt, I do find probable cause for the offense of battery. Further, I am ordering a bond of $500 in that case. I'm further ordering that you have no hostile contact with the victim in this case, that you maintain a separate residence from the victim, that you not return to the location where this incident occurred, with the exception of a one-time visit in the presence of law enforcement to recover personal items, that you possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. You are also picked up for a violation of probation, for which bond is set at no bond. Sean Fitzpatrick, thank you, ma'am. Sean Fitzpatrick, is that who you are? Sean Fitzpatrick? No? Okay. Well, who are you?
Naquaria Jones.
Jones Naquaria? Okay, so I do have a Sean Fitzpatrick, and then I have a Earl William Jones before Naquaria Jones. So what happened to Sean Fitzpatrick and Earl William Jones? It was in the system. I mean, I just go by what was in the system. I printed it in the exact order it was in the system. Yes, ma'am. Earl William Jones. Yeah, and Earl William Jones. So the order in the system is not necessarily the order the deputies have them in? Naquaria? I'm gonna go by what I looked at, which is this. This is the way it is in the clerk system. So, well, yeah, but I'm different than them. I'm me. and I'm going to do it. The way I've been doing it is I've been getting these papers from the clerk. And I find that even when I get the papers from the clerk, it's still not perfect. No, it's never perfect. So we're not gonna have a perfect day. We're just gonna have a productive day. Are you Sean Fitzpatrick?
That's me.
All right, are you witnesses for Sean Fitzpatrick?
Yes, Your Honor.
Okay, all right. Just how you did when you came over to the microphone, I need you to stay at that microphone so you can project well and I can hear everything you say. Well, the lawyers may have questions of you regarding this case. And who is this other person? Are you a witness or are you just here for moral support?
I'm a witness and a parent.
I mean, are you a witness or are you here for moral support?
He's a witness as well.
Okay, so both of you are witnesses and I'll take both of your names. Ma'am, you first.
Aaron Fitzpatrick.
All right, Ms. Fitzpatrick, thank you. And sir?
John Fitzpatrick.
And Mr. Fitzpatrick. What, I didn't catch your first name though.
John, John.
Okay, K-O-H-N.
John.
Okay, John, John. Okay, got it. All right, Ms. Fitzpatrick and Mr. Fitzpatrick, both of you, when you testify, you need to speak into the microphone. You can adjust it, of course, for your height. And the state will let you know if they have any questions. Defense will let you know if they have any questions.
Madam Clerk?
Please raise your right hand.
Raise your right hand.
Shaking.
Raise your right hand.
Do you solemnly swear affirm the testimony shall give be the truth, the whole truth, and nothing but the truth?
I do.
I swear.
Thank you. Which witness do you want to question first?
Miss Erin Fitzpatrick, please.
Okay, Ms. Fitzpatrick, you'll go first.
Do you have access to the microphone?
Yes.
Okay, very good. How do you know the defendant?
He is my brother.
Do you live together?
Yes.
While this case is pending, do you want to have contact with him?
No.
Has something like this happened before?
Yes.
Were drugs or alcohol involved in this incident?
Possible alcohol, no drugs.
Okay, I have no further questions, Your Honor. Mr. Fitzpatrick was a witness, but he is not a victim in this case.
Okay, all right. Mr. Fitzpatrick, thank you for coming. The state does not have any questions for you. Defense, do you have any questions?
I don't have any questions.
All right, defense has no questions for either witness. At this time, Mr. Fitzpatrick, the court does find probable cause for the offense of battery, domestic violence. I will set a bond of $500. Further, I will order that you have no contact with the victim whatsoever. You are also to not return to the location where this incident occurred, with the exception of a one-time visit in the presence of law enforcement to recover personal items. You must surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release and possess no firearms or weapons as a condition of your bond.
Okay.
Thank you, sir.
And that's just $500, correct? Your
Yes, ma'am. That's it. Earl William Jones.
I don't have that one.
Is he a VOP or?
VOP.
He's a VOP?
Yeah.
He's in my stack. The stack of papers that was given to me. He's in it. Mr. Jones, can you hear me?
Yes, ma'am.
All right, sir, you were picked up for on-site, on-view violation of probation for violation of a city statute or ordinance. And unfortunately, state, I do not have any information about the violation of the city statute or ordinance. If you have that information, you're welcome to present it at this time, but it was not in the case file in the clerk's system.
Do you want me to read it into the record, Your Honor, or would you?
If you have it,
Okay. The offender was ordered to probation for a term of 2 years by Judge Bob LeBlanc for burglary of occupied structure on 6/23/21.
that's not what I'm talking about, ma'am.
Are you talking about the new arrest?
Yes, ma'am.
Violation of Condition E of the order of probation by failing to live without violating any law by committing the criminal offense of alcoholic beverages sale and consumption restricted to in the violation of the city statute 33.09 on or about 8/5/22 in Orange County, Florida.
That's the same thing I read this morning. I don't need a recitation of what the violation of probation is. I need to know the facts that support that he committed the violation, that he committed the new law violation. There are no facts to support that. There's nothing that indicates how, when, where, and who are the witnesses to his commission of this city violation, the city statutory violation. Do you have that information?
No, Your Honor.
Do you want time to get it?
Yes, Your Honor.
All right, Mr.
Something, ma'am?
Mr. Jones, I want you to know that I did earlier this morning appoint the public defender to represent you in your case. I've appointed the public defender, so I prefer the public defender to first communicate with you, and then the public defender will let me know if it's something that needs to be brought to my attention.
Talking about.
Your Honor, are
Yes.
you wanting the affidavit for the possession of the alcohol, or you
Yes,
want it
ma'am.
to- You want that?
Do you have it?
Yes.
No, I know what you're saying.
Do you have it? Okay. Can you print it out for me? The clerk says she has it.
Read.
You sure you have it? Go to the next page.
Well, it doesn't matter if they found peace.
No, I wouldn't have been able to read it if it was any smaller. All right, Mr. Jones, the court is able to process you this morning, and we're going to proceed as follows. The court does find that there's probable cause for your own view violation of probation for violation of a city statutory ordinance for possession of alcoholic beverages. Sir, at this time, I am ordering no bond in your case. And as you know, I have already appointed the public defender to represent you. State, of course, that means we don't have to roll this to tomorrow.
Thank you, Your Honor.
Naquaria Lachey Jordan Jones. Mr. Jordan Jones, at this time, the court does find probable cause in your case for battery domestic violence.
Your Honor,
Yes, ma'am.
with regard to this defendant, I would like the court to know that there have been at least 4 other prior incidents of domestic violence with this victim, including when she was pregnant in 2021. And the only reason I believe you read in the affidavit they were together was because of the child that they now have together. So I would ask for something other than the $500 bond, Your Honor, based
Does
on
this-
that history.
Does this, and you said 4 times since 2021? Or was 2021 the last time before?
No,
this?
Your Honor, there was one in January of this year, but there were 3 in 2021.
All right. Regarding a bond, what, does the state have any suggestion?
I would ask for $2,000, Your Honor.
All right. The court, of course, in reading the probable cause affidavit, does take notes, and I noted that this was a particularly heinous type of a battery to commit on someone that you love, spitting on the person, throwing liquid on the person. And that, in addition to what the state has just advised the court of, the court does find that there is a basis for a higher bond than normal, and I will order a bond of $2,000. I will order no contact whatsoever with the victim. I'll order no return to, well, this actually happened outdoors, but no contact with the victim, maintain a separate residence from the victim, possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. State, do you think I've ordered enough to adequately protect the victim in this case? Because it happened outside, actually after a court hearing.
I believe that is all that we can do, Your Honor, but thank you.
All right.
You're gonna have to call.
Thank you, sir. Justin Manuel Laureano. This is the order I have them in. I don't know if that's one way or the other, but that's how I have them. Justin Manuel Laureano. Mr. Laureano? Sir, the court finds probable cause in your case for battery domestic violence, and I am ordering a bond of $500 in your case. I'm ordering that you have no contact with the victim in this case and not return to the location where this incident occurred. You do qualify for PTR, so I am going to go ahead and order that as an alternative, bond or PTR. The same conditions apply to both, either the bond or the PTR. Further, and finally, sir, you are ordered to possess no weapons or firearms and surrender any weapons or firearms to law enforcement within 24 hours of release. Rodney McElwain.
Follow him.
McElwain. Oh, I guess that they're, I see what's going on here is they are alphabetical in the clerk system. But you all categorize them by count, by charge. But the clerk system has them alphabetical. So somebody, if you all want me to do it the way that you all have them, someone's gonna have to come after I read them and tell me what order they're in, because they're in alphabetical order here. And that's why we have to all be on the same page. Mr. McElwain, can you hear me?
Ma'am?
Can you hear me?
Yes, ma'am.
So I find probable cause in your case for battery, domestic violence. I am ordering a bond of $500. I am also ordering that you have no contact with the victim. that you not return to the location where this incident occurred with the exception of a one-time visit with law enforcement to recover personal items. I'm ordering you to possess no weapons and no firearms and surrender any weapons or firearms to law enforcement within 24 hours of release. Sir, you also do qualify for the pretrial release program. And so if you should prefer to participate in pretrial release, I order that as an alternative, bond or PTR. The conditions of release will remain the same, whether you post bond or participate in PTR. Thank you, sir. Salvador Neris, is who I have next. N-E-R-U-S, Neris. N-E-R-I-S, Neris. Salvador is the first name. Mr. Neris has refused. Ms. Public Defender, I did appoint you, are you waiving his presence?
Yes, Your Honor.
All right, the court does find probable cause for violation of probation, drug probation, and bond will stay set at no bond in this case. Timothy Michael Faulkner. Timothy Faulkner. Is this for this afternoon? Oh, wait, there's some more. There's some more over here. I have it. Mr. Faulkner, so you do have two cases. The court does find probable cause for both cases, 2022 CF 8923 AO, count 1 aggravated battery on a pregnant female. The court orders a bond of $10,000. Count 2, battery domestic violence by strangulation. The court orders a bond of $1,000. You're ordered to have no contact with the victims, both victims in this case. You're ordered to surrender any weapons or firearms to law enforcement within 24 hours of release and not return to the location where this incident occurred. You are authorized a one-time visit in the presence of law enforcement to recover personal items. As to 2022 MM 185 AE, the court finds probable cause for resisting an officer without violence, and bond is set at $500. On the auto bond cases, the court takes no action on either one of them. Donald Mark Powers. P-O-W Powers. Mr. Powers, in your case, sir, the court does find probable cause for violation of your probation, condition 2, failure to report on or about May 1990 to probation as ordered by the court in violation of condition 6 for committing a new law violation of DUI on or about 12/31/1990 in San Jose, California. Bond will stay set at no bond on both counts. Kenneth Sham Reese. Kenneth Sham Reese. Mr. Reese, In your case, the court does find probable cause for violation of your probation. Condition 5, committing a new law violation of aggravated battery on or about 1/19/2019. A new law violation of criminal trespass on or about 1/19/2019. A new law violation of simple battery on or about 1/19/2019, all of which were committed in Lake County, Florida. The court will order no bond as to each count.
Can I say something, Your Honor?
I did appoint the public defender to represent you on this case, and so I prefer for you to speak with the public defender first, and the public defender will let me know if there's any information that needs to be brought to my attention. And the next case is Angel Lewis Rodriguez. Mr. Rodriguez, in your case, the court finds probable cause for the offense of battery domestic violence. I am ordering, in your case, a bond of $500, order that you have no contact with the victim, that you not return to the residence where this occurred, with the exception of a one-time visit in the presence of law enforcement to recover personal items. I am ordering that you possess no firearms or weapons and surrender any in your possession to law enforcement within 24 hours of release. Thank you, sir. Kiana Scott. Thank you, sir. Kiana Scott. Ms. Scott, the court finds probable cause in your case for battery, domestic violence, and I am ordering a $500 bond. Conditions of bond are that you have no contact with the victim, no return to the location where this incident occurred, with the exception of a one-time visit with law enforcement present to recover personal items, that you possess no firearms or weapons and surrender any in your possession to law enforcement within 24 hours of release.
Your Honor, can we do a maintain separate residence? He does not reside with,
I'm going to order both, no return and maintain separate residences, since I don't really know whether he resides there or not. Cassandra Segura Peralta. Cassandra Peralta. I don't usually do it that way. I usually read them from the papers. But I want to do the computer because I got to learn it. Well, I did learn it. I learned it today. I've learned it. Ms. Peralta? Ma'am, in your case, I find probable cause for the violation of your probation condition 1, violation of curfew on or about 7/14/2022 at 10:09 p.m., and for which bond will stay set at no bond. Thank you, ma'am. Jacquel Von Shea Thomas.
that will waive the appearance, Your Honor.
All right, appearance is waived. The court does find probable cause for the violation of probation. Bond is set at no bond. Roderick Tyndall. Mr. Tyndall, in your case, the court finds probable cause for the violation of your probation. Condition 5, committing a battery domestic violence on or about September 21st, 2021, in Orange County, Florida. Special condition, failure to pay financial obligations and currently being $90 in arrears. And special condition, failure to attend and complete the batterer's intervention program. Bond will be set at no bond on your violation, sir. Whitney Topus. Ms. Topus, the court finds probable cause in your case for battery, domestic violence, and I see that there is a gentleman. Sir, raise your right hand to be sworn in.
Do you solemnly swear affirm the testimony shall give be the truth, the whole truth, and nothing but the truth?
I do.
State
All
your
right.
name for the record, please.
It's Matthew Topus.
All right, Mr. Topus, I can hear you very well. Please answer out loud the questions that may be asked of you by either counsel. State, you may proceed if you wish to.
Good morning, sir.
Hello.
How do you know the defendant?
It's my wife.
Do you live together?
Yes.
While this case is pending, do you want to have contact with her?
No.
Has something like this happened before?
Yes.
Were drugs or alcohol involved in the incident?
This incident had
Yes.
recently happened. I don't think so, but I don't know if we weren't together until it happened,
Okay.
and I don't know if she had been drinking before or.
Okay. I have no further questions. Thank you. No further questions, Your Honor.
I do. Sir, the state asked you if you wanted to have contact with Ms. Topus, and unfortunately, I did not hear your response.
I do not.
Okay, thank you.
No questions from defense, Your Honor.
All right, ma'am, I do find probable cause in this case, and I am setting a bond of $500, ordering you to have no contact whatsoever with the defendant, not to return to the location where this incident occurred, with the exception of a one-time visit in the presence of law enforcement to recover personal items. You do qualify for pretrial release, so I will order that as an alternative, and the conditions will be the same whether you participate in pretrial release or post-bond. The final condition is that you possess no weapons and no firearms and surrender any weapons and firearms to law enforcement within 24 hours of release. Thank you, ma'am. Jasper Welch. And then I have three. Jasper Welch. Sir, in your case, I find probable cause for the offense of aggravated battery, domestic violence with a deadly weapon, and bond is set at $3,500. I also find probable cause for the count 2 kidnapping with a weapon. However, state, I'm gonna need your input as to a bond.
Your Honor?
The weapon, I think, was a baseball bat,
Yes, Your Honor.
not a firearm. So it's kind of, I want to set a bond. I just struggling with the amount of the bond because it was a baseball bat, not a firearm.
Your Honor, it doesn't have to be a firearm. It just has to be a weapon.
Mm-hmm.
And based on that, because it's kidnapping with a weapon, it's a first-degree felony, punishable by life. The state would ask he be held no bond.
Defense, do you agree with that?
Yes, Your Honor, my understanding was that it was.
All right. Well, I'm going to go with the state on that because my bond schedule does not even address a non-firearm. So I'm just going to go with the state, and I'm going to order no bond, sir, and order as a condition of the no bond and the bond that I set on the aggravated battery, that you have no contact with the victim, that you possess no weapons or firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release and not return to the location where this incident occurred. All right, are these the motions? Okay, so this is an out-of-county add-on? Okay. Kristen Abigail Gilmore,
Bonded, Your Honor.
bonded on a $500 bond. Oh, yeah, you bonded. Is that it? Okay, now we'll do the ROR motions. 2022 CF 7376, Christine Alamany. Any objection to granting this motion, state?
Yes, Your Honor, information was filed.
All right, this motion is denied in that an information has been filed. I don't date them. You can date them for me. Floyd Eugene Anderson, 2022 CF 6595 AO. State.
Objection, information was filed.
All right, this motion is denied as information has been filed. 2022 CF 7732AO, Brian Jose Colon de Leon. Any objection to granting this motion?
No objection.
All right, this motion is hereby granted. Samuel Valentine Felix, 2022 CF 7907AO.
Objection, information was filed.
All right, this motion is denied as an information has been filed by the state. 2022 CF 7858AO, David Blake Hing.
No objection.
This motion is granted, no objection from the state. And 2022 CF 7963AO, Rudolph Langley.
No objection.
No, motion's granted, no objection from the state. 2022 CF 7857AO, Carlos Elijah Pena III.
Objection, information was filed.
This motion is denied per the state and information is filed. And 2022 CF 7934AO, Christopher Shaw.
I apologize. Objection, information was filed.
All right, this motion is denied. Information is filed per the state. 2022 CF 7845AO, Elijah Smith Jr.
No objection.
No objection. This motion is granted. 2022 CF 7897AO, Timothy Paul Taylor.
No objection.
This motion is granted. No objection from the state. 2022 CF 7899AO, Shantia Renee Warren.
No objection.
And this motion is granted. No objection from the state. Madam Clerk, anything else? All right, court stands in recess. Turn this computer on
Okay.
in case I need it.
Oh, just in case, yeah.
I need it, and sometimes I do not. Where is she? There she is. We are on the record for the afternoon session of initial appearances and arraignments. And I'm Judge Allen presiding, state announcer presence followed by defense counsel.
Brenda Eugene on behalf of the State Attorney's Office.
Letitia George on behalf of the Office of the Public.
Thank you both. Are these the arraignments?
Yes, ma'am.
Okay. All right, commencing with the arraignments, Christopher Robert Smith. Oh, well, where is everybody? Ms. George, well, why don't you let me know in advance if any cases that you are aware of, you may not be aware, but any that you are aware of that are going to be a plea.
Okay.
There seem to be
This,
quite a
Mr.
number of these this afternoon. So, are you aware of any?
Mr. Smith does have an offer, Your Honor, but when I went back, we were.
So you're just not aware?
No, he does have an offer, but.
No, I just want to know if you know any that are a plea.
Oh, yes, Your Honor. Smith is a possible plea. He just wasn't brought up for me.
Okay,
to
so
talk.
you're just not aware of any that are a plea at this
No,
point?
I am Butler.
Butler is a plea?
Yes.
Okay, and,
That's the only ones is Butler and Smith that I know.
okay, so not who's a possible plea, but who is a plea?
Okay, just Butler for now, Your Honor.
Okay, and I don't have a butler, but I'm sure I can get a butler by the time that we get one. Third, oh, sorry, I thought it was the second. Braddock, Butler.
So what's it? No.
Okay. Braddock, Marcel, Matthew. Sir, what's your name? Mr. Smith, you're here for an arraignment on a charge of driving while your license was suspended or revoked with knowledge. The public defender's been appointed in this case.
This was Braddock, Your Honor. The offer from the state is in adjudication, I believe, credit time served. He was just brought up. Could I have a moment to speak with him, Your Honor? He was not brought up at the time.
Are you not allowed to go behind that door and speak with people?
She just arrived to the floor, Your Honor.
Oh, okay.
I'll go back here.
No, I'm talking to Ms. George right now. Ms. George, are you not allowed to go behind that door and speak to people?
If, Your Honor, if I was to ask somebody to walk with me, yes. But we don't,
Can you just answer my question? Are you allowed or not?
yes, Your Honor.
All right, well, could you please make sure that you do that ahead of me coming into the courtroom and speak to the people? You have the list, you know who's coming to court, right?
Yes.
You seem hesitant.
Because the issue, Your Honor, is that with some of, it would be hard for me to go down there.
I didn't ask you to go down anywhere. I asked if you could go behind that door. I don't know what's behind that door. Let me just give you a visual of what I think is behind that door. I think that there are a number of people behind that door who are scheduled for court at 1 o'clock. And I think that they're lined up in some kind of an order. And then I think that almost everybody that I have on my list is behind that door. Am I wrong in thinking that, Deputy? So if all the people are behind that door, I'm asking, can you go behind that door? I am not asking you to go to any facility. I am not asking you to go upstairs or downstairs. I am asking if you can go behind that door, if the defendant is back there behind the door. And I think you said, yes, you can do that. Now, anything else adding on, going to different locations, I didn't ask about that. I'm not asking you to do that. I'm just asking you to go behind that door. People are here. And you did say yes, you did say you could do that. And
Yes,
just make sure you do it.
he just wasn't up, Your Honor. That was the issue.
Well, I wasn't really asking about him in particular. I mean, why is everybody expanding what I'm asking? I'm simply asking, can you go behind that door? And if you can, for the people who are present behind that door, please do so. For people who are not behind that door, obviously, I'm not asking about them. I'm not asking about people who are in different locations. Ms. George, just people behind the door who are waiting to come to court. And now, in his case, you're asking for additional time to talk to him. I'm not going to grant any additional time. I'm going to move on to the next case.
We'll enter a plea of not guilty.
Not guilty plea entered.
Case to be heard in Division 82. Pretrial conference is September the 27th. September the 28th at 9 a.m., courtroom 9B.
Marcel Matthew Braddock.
Virgin Marcel Jessica from Galaxy Girl.
I'm sorry, I couldn't hear you because I need you at the microphone. Go ahead. Did you want to say something? All right, you're here for your arraignment on a charge of battery.
And we'll enter a plea of not guilty, Your Honor.
Not guilty plea entered.
Case to be heard in Division 80. Pretrial conference is September the 22nd at 9 a.m.
Am I going to be released today?
No,
Am I going to be released today?
I apologize,
Not today.
Madam Clerk. I didn't hear the
Can I
courtroom.
have RRR?
no,
I don't get RRR bail today?
not today.
I am innocent. Why don't I get RRR?
I want your attorney to talk to you about that.
When's my court date?
September the 22nd.
When's today? What's today's date?
August the 8th.
August 8th? And my court date's not till September 22nd?
That's correct.
And this is for what? For what? What's my charge?
Battery.
And is it municipal or felony?
It's not a felony, I don't believe, but I'm not sure if it's
Why don't I
municipal or
get credit for
county.
time served? I've been here 100 days already.
I show you've been here 38 days, and I'm going to allow you to talk to your attorney about any other specific
Well,
details.
I've got time served.
Cynthia Darlene Butler. Ms. Butler? You're here for an arraignment on a charge of trespass in a structure. I'll enter a not guilty plea on this.
Your Honor, this is the one,
No,
Butler.
I'm guilty. I did, but it was just the lease in office, ma'am.
Can I get the pen, please? The
Ms.
offer-
George, is she trying to accept the plea offer?
Yes, Your Honor, the offer from the state is an adjudication of guilt, credit time served, and no return to 744 Spring West Road. Thank you.
Has she had a chance to review the plea form?
Yes, we went over it in the back, Your Honor.
Okay.
Let me read it. I didn't read it.
You can read it.
Ma'am, I cannot accept a plea until you read the plea form. Step to the back, and once you finish reading it, we'll recall your case. Scotty Coburn. Scotty Coburn.
And I will enter a plea of not guilty.
All right, this case is, are you waiving the arraignment and entering a plea of not guilty?
Yes, Your Honor.
All right, this case will be scheduled for pretrial conference.
Case will be heard in Division 80. Pretrial conference is September the 22nd at 9 a.m. Courtroom 9C.
Danielle Daniels. This case has regional counsel, so I will reschedule it for 24 hours due to medical. Yes. Oh, today's the 9th. Oh, I just said it was the 8th. I was one day off. I was still operating on yesterday. Vincent Anthony Donis. Ms. Public Defender, you all have been appointed on that case.
And I will waive and enter a plea of not guilty.
All right, a plea of not guilty is entered to be set for pretrial conference.
81. Pretrial conference is September the 2nd at 9 a.m. Courtroom 6B.
Yissa Emmanuel. Medical also. Public Defender previously appointed.
I will waive and enter a plea of not guilty, Your Honor.
All right, set it for pretrial.
Case will be heard in Division 85. Pretrial is August the 29th at 9 a.m. Courtroom 4A.
Andrew Xavier Ford. All right, Public Defender was appointed.
I will waive and enter a plea of not guilty.
All right, case will be set for pretrial.
Case will be heard in Division 50. Pretrial conference is September the 2nd at 9 a.m. Courtroom 4E.
Stacy Foster. Okay, this is another regional council case, so I'm gonna roll it. To 24 hours. Elvis Gainey. Right. So you're here for an arraignment on a charge of violation of a domestic injunction. I'm going to enter a not guilty plea and schedule your case for a VOP status hearing. You were picked up for a violation of probation on a domestic injunction, and I'll be setting your case for a VOP status hearing.
She entered a denial.
I entered a denial.
Okay. Case will be heard in Division 50. VOP status is September 19th at 9 a.m. Courtroom 4E.
Elvis Leon Gainey, also a violation of domestic.
Same case. He got two cases.
Yes, this is the second case, sir.
Both of them is in Division 50.
Hold on a minute, let me look at this one, because there's a count two, battery, domestic violence. Okay, as to both counts, sir, I will enter a denial and schedule this case also for a VOP status hearing.
Same case, Division 50, VOP status is September the 19th at 9 a.m. Courtroom 4E.
Terry Petit. Mr. Petit, sir, you're here for an arraignment on a charge of trespass on an occupied structure and refusing to leave. The public defender was previously appointed in this case.
I will enter a plea of not guilty, Your Honor.
Not guilty plea entered, set for pretrial.
Case to be heard in Division 81. Pretrial conference is September the 2nd at 9 a.m.
David Edward Rogers.
Courtroom 6B.
Oh, I'm sorry. David Rogers. Mr. Rogers? Not Mr. Rogers? Okay. Eric Lamont Smith? Mr. Smith? Sir, you're here for an arraignment on a charge of exposure of sexual organs.
You do not have an attorney.
No attorney has been appointed to represent you. Sir, you do have the right to have a lawyer on this case to represent you, and if you cannot afford to hire a lawyer, I will appoint a public defender to represent you. Would you like for the service of the public defender in this case? Did you say yes or no?
That's not why I've been here.
Sorry, sir, the public defender is a lawyer that can represent you on this criminal charge. And because of the fact that you are incarcerated right now, you in all likelihood do qualify for the services of the public defender. There is a $50 application fee that would be assessed towards the case. Would you like to fill out the application for the public defender to represent you as your lawyer in this case? Yes or no? I can't hear you. Oh, why would you need the public defender? It's your choice, sir. If you do not wish to have the public defender, you can say no. And if you wish to apply for the public defender, you can say yes, and then I'll give you the application and we'll let you fill it out. Was that a yes or a no? I just can't hear you.
Multiple lawyers, though.
Okay.
Why would I need a public defender?
All right, I'll take that as a no, that you do not wish to fill out the application for the public defender. The case will be scheduled for a pretrial conference.
Your Honor,
Yes,
can you
ma'am.
confirm that the summons was actually served on this defendant?
Yes, Madam Clerk, can we confirm that? Do you have reason to believe that it was not?
Yes, Your Honor, the summons was actually issued August 5th, and I was trying to get it served, but as of 5 o'clock yesterday, it had not been yet.
Okay, so, Madam Clerk? That would be a no according to the clerk's system. All right. Is he being held on multiple cases like he says?
No, Your Honor, he's only held on a battery case.
And does he have a bond on that case? The battery case?
He does, 500.
Okay. So, state, what is the state's intention about this exposure case?
He will be served, Your Honor, now that they've been notified that he's in jail. It's just a delay.
All right, so the state still intends to move forward on this case?
Yes, Your Honor.
All right, we'll reset this case. State, how much time do you need?
A week, Your Honor?
Reset the case for in jail arraignment for 1 week. I'm sorry.
We reset for August the 16th.
Wait a minute. This gentleman here, let me see this. State, do you have any prior history on this gentleman, Eric Lamont Smith?
1 moment, Your Honor.
Or, excuse me, madam, I'm sorry, I didn't catch your name. Davis? Ms. Davis, do you have any history on this gentleman, mental health related history on this gentleman? I just can't hear you, sir, and I'm concerned because I know you're saying something, I just cannot make out what you're saying. I just cannot hear you.
It's the only way you would be able to hear.
Ma'am, Your Honor, I apologize. My system appears to have shut down.
All right.
No, Your Honor, I don't
Ms.
see-
Davis, you don't have anything? All right, well, we'll just leave it as is for now.
Your Honor,
Yes,
I
ma'am.
do.
Yes, ma'am. Ms. George, you have something?
Yes, in case number 22 MM3396 AO, there was an evaluation that was supposed to take place here. It looks like the state didn't move forward on the charges, so I'm not sure if it was ever done. So
So,
there is competency issues, and that was recent.
okay, that was in 2022, MM 3396AO. Was the case now paused or dismissed, or what happened on the case?
Case was no billed, Your Honor.
No bill? All right. So, the court is, just based on the responses between the defendant and the court does have some competency concerns in this case. And under those circumstances, the court is going to appoint the public defender to represent the defendant. The defendant is incarcerated, and so that means he is not working and he is indigent. The public defender is appointed. We still are rescheduling the in-jail arraignment due to the fact that he was not served. The summons was not served. We're still going to reset it, but now the public defender is representing him. Yes, ma'am. David Rogers, who was it that you said that? Okay, David Rogers is medical. Public defender was appointed on this case.
And I will waive and enter plea of not.
All right, plea of not guilty, reset that for a pretrial conference.
Denial, excuse me. He's here.
A denial, set it for BOP status.
I'm sorry, Your Honor.
Yes,
He is
ma'am.
here, Your Honor.
Jail staff is saying, he's here? No, Rogers.
I'm so confused.
Rogers is medical, that's who we're doing right now. And he will be set for a BOP status.
Case to be heard in Division 63. BOP status is August the 25th at 9 a.m., courtroom 10B.
Vincent Lamar Williams. Mr. Williams? Is that refused?
And
All right, Mr. Williams is gonna have to be reset because he doesn't have a lawyer appointed. Tomorrow?
Your Honor,
Yes, ma'am.
if we could also reset this to August 16th, I think this is another case where the summons hasn't been served yet.
Oh, okay, Madam Clerk, can you confirm that? And if so, then I'll roll it to, for 1 week. Now we'll call back Ms. Butler. She should have had, who's this gentleman? Okay, well, let's just go ahead and take care of Ms. Butler to get all the arraignments done.
Yes, ma'am.
Did you confirm that no summons? All right, reset it for next week, 7 days.
yeah, I already talked.
Ms. Butler,
Yes, Your Honor.
have you had a chance to read that plea form now?
Yes, ma'am.
All right, I'll take the plea form. Mr. Eugene, remind me if your client's entering a plea of guilty or no contest.
No contest, Your Honor.
All right, Ms. Butler, ma'am, is this your signature here at the
Ma'am.
bottom of this plea form? Did you read this document in its entirety before you signed it?
Yes, I took the time.
Did you have any questions about anything contained on this docket that your attorney has not yet answered on your behalf?
Will there have to be a $500 fee to?
I'll talk to you about the fines and court costs in just a moment. Do you understand that you are giving up all the rights on this plea form by entering your plea of no contest? Yes or no?
Yes.
Are you under the influence of any alcohol, drugs, or medication?
No.
Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes.
And this is off the arraignment docket. Counsel, do you stipulate to a factual basis?
Yes, Your Honor.
All right, the court finds there's a sufficient factual basis based upon stipulation of counsel, and I find you to be alert and intelligent. I will adjudicate you guilty. I am ordering that you pay the mandatory court costs in this case. How much are the court costs? And how much time served? The court costs are $323, ma'am, and I'm going to give you 364 days to pay that. I'm going to order you to be released as to this case. You must make your payments directly to the clerk of courts. Does that answer your question that you
Yes,
had
ma'am.
about the money?
Yes, ma'am.
All right. Also, I am ordering you to not return to the location where this incident occurred, 744 Spring West Road. You also are giving credit for the time that you have served. I show 21 days, is that correct? Correct. In the amount of 21 days. You are released as to this charge. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Do you have any questions?
Yes, $650 was paid for bond for me to get out when I first arrived.
I don't know if it was a cash
And I
bond.
will-
If it was a
and I-
cash bond, the clerk would tell me and I would apply it. But if it's a surety bond, then I cannot apply it.
It was cash and it was also a ATM card.
Hold on a moment.
On this case,
No, Your Honor, I don't see that there was a bond posted for this case.
All right, ma'am, it looks like you're confusing this case with another case, so the order stands as the court has imposed it.
Okay.
Thank you. 364 days.
Your Honor?
Yes, ma'am.
She's a diver. She's not the original person. She's a diver on somebody else's body. That's all I have.
Oh, wait a minute. Come back. Ma'am, are you calling the public defender a diver?
Diver is, in the Bible, it speaks about in the last time, there will be divers. In the past time, there will be divers. The stuff that goes out there that you guys call.
And you are calling the woman who's standing
It's called a
next,
diver.
the woman who's standing next to you, you're calling her the
Not
diver.
the person that's on the body, but the stuff that's on the body. It's called a diver. It's many people that gets on other people's body and become that person.
Can I ask you a question? The person who's standing next to you, you don't believe she's your public defender? You think she's a diver?
Her.
She has another public defender as well, Your Honor.
Miss Public Defender, let me talk to her for a moment, please. So, ma'am, I know her to be the public defender in this case, and I also do not believe that she is a diver.
Show you later.
One moment, ma'am, one moment. And Miss Public Defender, because she is exhibiting some unusual signs, I am going to withdraw the plea and order the public defender to look into her ability to accept the plea, her competency to accept the plea. However, if the state has no objection, I will ROR her.
No objection, Your Honor.
All right. So, ma'am, I am going to release you as to this charge, but I am withdrawing the plea, and I believe that you need to have a little bit more of a office consultation with your lawyer so they can assess whether you completely understand what you're doing in this case. And so you will need to make an appointment with the public defender. Perhaps we can clear up what's going on based on that, okay?
Because she stated to me that she would see me again one day, and she'll be on somebody's body. She'll see me again, and this is.
Well, we're going to make sure that you get the attention that this case needs from whoever Mr. Wesley assigns to represent you in this case, okay?
Thank you, Your Honor.
Well, we're going to have to set it for something. The public defender tells me what they want to set for.
Yes.
Pretrial conference.
be heard in Division 82. Pretrial conference will be September the 28th.
Please make sure the court minutes indicate that the court had accepted a plea, then there became competency concerns, the court withdrew the plea and asked the public defender to explore the competency issues.
Madam Clerk, I apologize. Can you repeat the pretrial date for Ms. Butler?
September the 28th at 9 a.m., courtroom 9B.
Thank you.
Okay, who do I have standing right here in front of me?
Derek Kuntz.
Derek Lionel Kuntz.
Yes, ma'am.
Sir, in your case, the court finds probable cause for the offense of trespass on property other than a structure or a conveyance. And I set a bond in that case of $250.
Your Honor, on this particular case, the state was offering an adjudication of guilt, 5 days in the Orange County Jail with credit for two with credit for 2. There's a no return to 6250 West Colonial Drive. Mr. Kuntz would like to accept an answer plea of no contest.
All right, that's acceptable.
No contest.
Thank you, Mr. Kuntz. Is this your signature here, sir, at the bottom of this plea form?
Yes.
Were you able to read this plea form in its entirety before you signed it?
Yes.
Do you understand that by entering a plea of no contest, you're giving up all the rights on the front of the document?
Yes.
Are you under the influence of any alcohol or drugs or medicine that would affect your thinking this afternoon? Do you understand that a conviction on this case will subject you to being deported if you're not a U.S. citizen?
Yes, I
There
understand.
is a sufficient factual basis in your case, sir. You are alert, you are intelligent, and I will adjudicate you guilty. How much time served?
Yes, 2 days.
Order 2 days in jail with credit for the 2 days you have already served, and order that you pay mandatory court costs in this case, as well as that you not return to 6250 West Colonial Drive. Further, sir, I am ordering your release as to this charge. I am ordering that you make all payments through the clerk of court within 364 days of today's date. Do you have any questions?
Your Honor, it was 5 days with credit for 2.
Oh, I'm sorry. Is that what it said? Sorry. Now change that to, and that's what you wrote too. 5 days in jail with credit for 2 days' time served. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you. Who's next?
Michael Taylor.
Michael Taylor.
Yep.
Taylor.
Keep your mask on, they're gonna get you.
Mr. Taylor, sir, in your case, Michael Allen Taylor. Sir, in your case, the court finds probable cause for count 1, possession of an open container, and I'll set a bond of $100.
In your Honor, the
Yes, ma'am.
offer from the state was a withhold of adjudication credit time served.
Okay,
Mr. Taylor would like to accept and enter a plea of no contest.
okay.
There wasn't even nothing in the can.
He has 2 days, Your Honor.
Picked it up, but there was nothing.
Mr. Taylor,
Yes.
the document you're signing, were you able to read it?
Yeah.
Okay,
It's right here.
all right.
There wasn't even nothing in the can. He knew that.
Ms. George,
Yes,
does he understand what's going on?
Okay.
he does, Your Honor. I spoke with him in the back.
Okay, Mr. Taylor, this is your signature here at the bottom of this plea form?
Yep.
And you told me you read this document, is that correct?
Yep. That's it.
At this time, Mr. Taylor, do you understand that by entering a plea of no contest, you're giving up the rights on the plea form?
Yep.
Are you under the influence of any alcohol or drugs or medicine at this time?
Medicine.
Does the medicine affect your ability to understand this court proceeding?
No.
All right, and did it affect your ability to communicate with Ms. George, the lady who's standing beside you? She's your lawyer?
No.
Okay. Do you understand that a conviction on this case will subject you to being deported if you are not a U.S. citizen?
Yes.
All right, sir, I reviewed your file. There's a sufficient factual basis. You are alert, you're intelligent, and I will withhold adjudication of guilt and order 2 days with credit for 2 days' time served. Is that correct? 2 days?
Yeah.
And I will order mandatory court costs, which must be paid within 365 days of your release, and which I am ordering your release as to this charge. Do you have any questions to ask me?
No.
You have the right to appeal the sentence if you wish to appeal.
Well,
Hold on a minute. If you wish to appeal, you must do so in writing within 30 days of today's date. So I gave you 364 days to pay it. If you cannot pay it in that time, you must request an extension of time from the clerk of courts.
I'm telling you now, I got a job and I don't get my check. They don't give me my, never gave me.
But you can request an extension of the payment from the clerk of courts if you need to.
All right.
Okay, thank you. All right, who's next? Allen, Cameron Jerome Allen. No, I didn't touch these. I mean, no. I mean, yeah, I don't care.
It's a felony.
Doing that. Mr. Allen, is that who you are? All right, sir, the court finds probable cause in your case. You have multiple counts. Count 1, possession of cocaine with intent to sell or deliver with a weapon, and bond will stay at $10,000. Count 2, possession of cocaine with a weapon, bond will stay at $150. Count 3, possession of methamphetamine with a weapon, bond stays at $150. Count 4, possession of methamphetamine, bond stays at $150. Count 4, Count 5, sorry, possession of 3,4-methylene methamphetamine MDMA ecstasy with a weapon. Bond stays at 150. Count 6, possession of 3,4-methyl methamphetamine MDMA ecstasy. Bond stays at 150. Count 7, possession of a firearm by a convicted felon, and bond stays at 150. Count 8, possession of ammunition by a convicted felon, bond stays at 150. Count 9, possession of tetrahydrocannabinols, bond stays at 150. Count 10, possession of cannabis greater than 20 grams, bond stays at 150. Count 11, possession of cannabis with intent to sell or delivery with a weapon, bond stays at 150. Count 12, possession of a firearm with an altered serial number, bond stays at 100. And count 13, possession of drug paraphernalia, bond stays at $100. Mr. Allen, you had several out on bond cases, 2022 CF 2010AO, 6 counts. The court will revoke the bond and set no bond on all 6 counts. And 2022 CF, can't read my own handwriting, 2817AO, 8 counts. The court will revoke bond and set bond of no bond on all 8 counts. The public defender is appointed to represent you in the case. Thank you, sir. Terry Byerly. Mr. Byerly, you were picked up for failure to appear. The bond is set at no bond, or remains set at no bond. Jose Emilio Echevarria. Mr. Echevarria. The court finds probable cause for the charge of trespass on property after a warning, and bond is set at $250.
Your Honor, as to the trespass, the offer from the state is an adjudication of guilt. Credit time served, no return to 7209 South Orange Blossom Trail.
And what's the time served in that case?
Oh,
2 days, and it's a time served offer?
yes, Your Honor.
All right, that's acceptable. Has he read the plea form?
We went over the plea form, Your Honor.
Let me also note that on the out on bond case, the court takes no action as to Mr. Echevarria. Mr. Echevarria, is this your signature here at the bottom of this plea form?
Yes, Your Honor.
And do you have an opportunity to read this document, sir?
Yes.
Sir, are you under the influence of any alcohol, drugs, or medicine at this time?
No, Your Honor.
Do you understand that by entering a no contest plea, you're giving up the rights on this form?
Yes.
Do you understand that conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes.
There's a sufficient factual basis to accept your plea. You're alert, you're intelligent. I will adjudicate you guilty, order 2 days in jail with credit for 2 days' time served. I'll order you to pay all mandatory court costs in this case and order you not to return to 7209 South Orange Blossom Trail in Orlando, Florida. Sir, I am ordering your release as to this charge, and you must pay all mandatory court costs within 364 days of today's date or of your release. If you are unable to make the full payment in the time I've ordered, you must request an extension of time from the clerk of court. Thank you, sir. One other thing, you have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Any questions?
No, ma'am.
All right, thank you.
Thank you.
Francisco A. Garaldi Baez.
And I will waive the appearance, Your Honor.
The court finds probable cause in this case for burglary of dwelling. Bond stays at $5,000. Court revokes the bond as to 2022 CF 8905. And a new bond is imposed of $2,000. The court is ordering the defendant to have no contact with the victim and not return to the location where this incident occurred as a condition of bond. As to case number 2022 CF 9265, Luis Giraldi Baez.
And I will waive the appearance, Your Honor.
Court finds probable cause for burglary of a dwelling and sets a bond of $5,000. Orders the defendant to have no contact with the victim and not return to the location where this incident occurred. Clifford Isaiah Grant Sutton. Mr. Grant Sutton, in your case, the court finds probable cause for the charge of trespass after a warning and sets a bond of $250.
Your Honor, can we, pass Grant Sutton? He,
Mhm.
when I spoke to them back there, he wasn't, up yet. So if he could just have a moment to review the offer.
All right, he has multiple cases. Is the offer just on one case or all cases?
All.
All right, yes, we'll recall him.
Thank you.
Robert Harris. Mr. Harris, the court finds probable cause in your case for count 1 battery with a prior battery. Bond stays at $2,500. Count 2, possession of 3,4-methylene methamphetamine MDMA ecstasy. Bond stays at $150. Count 3, fraudulent use or possession of an ID of another, and bond stays at $100. The out on bond case, the one that I looked at, does not appear the state has filed charges. Actually, I looked at 2 of them. I just wrote them in different places. And state, if I'm incorrect in that, please let me know.
No, Your Honor, the state has not filed on either one of the.
All right, and in that case, the court will take no action on both of the out on bond cases. Sir, as a condition of bond, the court is ordering you to have no contact with the victims, not to return to the location where the incident occurred, that you possess no firearms and no weapons, and surrender any firearms and/or weapons to law enforcement within 24 hours of your release. Thank you. Oriel Haver Phillips. Mr. Phillips, the court does find probable cause for the charge of grand theft, 3rd degree of a motor vehicle, and bond stays at $1,000. You're ordered to have no contact with the victim and not return to the location of the victim's home. Thank you, sir. Delbert Desmond Henry Jr. Does the public defender wish to waive his appearance? The public defender is waiving his appearance. The court does find probable cause for attempted burglary of a dwelling, occupied dwelling, and bond stays at $5,000.
Your Honor?
Yes, ma'am.
With regard to this case,
Yes, ma'am.
there's a slight issue with it. He's already been seen for IAs, I believe it was yesterday. However, he's already been seen and it's the same charges. One, he was just arrested and then they issued a warrant. So we are trying to find out if the court can just ROR him with regard to the warrant charges, but we don't want him to be released ROR. We just don't want him to have to pay double for the same charges.
So was a bond ordered on the case yesterday?
Yes, Your Honor.
Okay, so so you have no objection to me granting, or you're requesting an ROR on these counts here today, because are they a duplicate?
Yes,
or-
they are a duplicate, Your Honor. However, we're just trying to find out how to do it administratively so that there's no confusion with the jail, and so he's not released ROR because it's the same case number and it's the same charges. The only thing that's different is the agency case number.
Well, yeah, I guess we can put our brains together and figure that one out, because we're all intelligent people. Would you approach?
Yes, Your Honor.
And we'll put our brains together. Miss Public Defender, I think your presence is needed
Yes, Your Honor.
on a different case.
Yes, Your Honor. Yes.
And Ms. Clerk, yeah, Ms. Clerk, she looked at me like, well, I gotta be involved in this. You might be as smart as one of all of us. Ms. Clerk, can someone tell me the case number from yesterday? So it's the same case number. So I was the judge. I'm the one who ordered the bond. Yes.
It's on the 6th.
And so we're pretty sure it's the same set of facts and not two different cases. Print it out. Because I mean, I did read it. I just want to know, did you print out the one from last week or the one from today? Because I read the one from today. Okay. So, but I'm just gonna go with the state on this. We're pretty sure that the same set of facts for both cases. Okay. So now tell me the date of the order from last week. What's the date of that order? No, the order by the judge. So the day the judge ordered the probable cause and the bond.
August the 6th.
Okay, August the 6th. And what exactly did the judge order? He stayed the bonds?
Yeah, stay the bond.
Did he stay, or she stay 5K, 1K, and 500?
It was 2,500.
Okay, so it went up. So 2,500.
Maybe 150 on count two.
50.
There's no return to the scene.
Okay, so, and let's see. So what I can do is I can just put a note in the file that the order that was entered on August 6th, 2022 should be complied with and supersedes my ROR that I'm going to order here today. And as to the ROR, must say, see order of August 6th before releasing defendant. In big, bold letters. All caps. And now that is, and now does anyone have a better suggestion than that? That's what I'm gonna do.
It's fine.
Everybody likes my suggestion? All right, I will take other suggestions now. I will. I'll take other suggestions. All right, Madam Clerk, let me look at that one, but just, the main thing is big, bold letters, so that the booking people, the release office, when they look at it, they will have to look at that order. What you trying to do?
See if I have
A highlighter? I have a pink one right here. Is that gonna work? Somebody put it. There's a pink one. You don't think they'll see that? They won't, okay. So, but they can see the bold though, right? All right, let me look at it. Set that one aside and let me look at that order special, okay? And then, yeah, okay, all right. Okay. Who's next? Jamal Travis Jeffers?
Mr. Grant Sutton, Your Honor, is
Grant
ready.
Sutton, recalling Grant Clifford Isaiah Grant Sutton.
And Your Honor, the offer in case number 2022 MM5332AO, the new law is an adjudication of guilt, credit, time served, no return to 2655 South Kirkman Road. As far as his out on bonds in case number 2022 MM 3860AO, the offer is an adjudication of guilt, credit, time served, no return to 3250. Is it Burton Boulevard? Okay. Cost investigation in the amount of $58.28 to the Orlando Police Department. And that? They haven't filed it. No? Your Honor, I would ask that, and then I would ask that you take no action on the 2022 MM4483 AO. I don't believe an information has been filed yet, is what I saw. So I would wait to resolve that. I don't know. That's what I saw.
Yes, ma'am. State any objection to me taking no action on that case?
No objection, Your Honor.
All right. I'll take no action on 2022 MM4483. In light of the defendant's resolution on the other cases, I will take no action.
I just crossed it out. Your Honor.
How is the defendant entering the plea?
No contest, Your Honor.
All right. Mr. Grant Sutton, is this your signature here at the bottom of this plea form?
No.
Is this your signature at the bottom of this plea form?
Yes, ma'am.
Did you read the plea form before you signed it?
Tried to, miss.
I'm sorry?
I tried to.
Is there a reason why you couldn't? You tried? Is there a reason why you could not read it?
No, ma'am.
Are you able to read?
Yes, ma'am.
Okay, so can you read it for me?
Your Honor, if I may, he tried to read it. I had to come to the side and go over it with him because he was a little confused by what was on the form. So I went over it with him right here.
All right, sir, listen to me. I do need to know that you understand what is on this plea form. So
You just don't want me going back to the store, right, miss?
it's a little bit more in-depth than that. I need to communicate with you and be sure you know what's on that plea form. There are rights on that plea form that you're giving up. So if you can read, I do need you to read it. If you cannot read, then we'll arrange to have it read to you. You can read?
Yes, ma'am. I can read.
All right, so you want to read it for me then?
I have another one, Your Honor.
Just let him read the one he signed. Might as well read the one he signed.
Yeah, I approach.
Yes. Sir, it'll probably take you about 5 minutes to read that, 3 or 4, 5 minutes. So I'm going to pass your case and go to the next person, but we'll come back to you as soon as you're finished reading that, okay? All right, and Jamal Travis Jeffers? All right. You were picked up for violation of pretrial release as to 2 counts, and as to both counts, bond will be set at no bond.
Sorry, I didn't understand that.
I'm sorry?
I didn't understand what you said just.
Okay, let me repeat it. So you were picked, are you Jamal Travis Jeffers?
Yes.
All right, you were picked up for violation of pretrial release. You understand that?
Yes.
All right, and there is no bond that's ordered. You had 2 counts that you were on pretrial release, and the judges are ordering no bond, and so I'm informing you of the no bond as to that violation. You understand now?
Yeah, I understand that.
All right, and I did appoint the public defender to represent you. Stephen Kenny LaRoche. Mr. LaRoche?
Yes.
You're charged with trespass after a warning for which the court does find probable cause and sets a bond of $250. And the court takes no action on the out on bond case, but as to the trespass, you're ordered to not return to that location and have no contact with the victim.
Okay, you're going so fast.
Sorry, Ms. George.
Your Honor, there was an offer to resolve the case of an adjudication of guilt, credit time served, no return to the Orlando International Airport without a valid ticket, and Mr. LaRoche would like to accept an enter plea of no contest.
All right. Has he had a chance to read his plea form?
Your Honor, we went over it. If he could
It's basically not returned to the airport, right? Trespass for
A little
1
bit
year?
more involved than that, sir.
Right.
And we'll talk about all of the conditions.
And that's what this says. You understand that?
Well, what rights? It's an airport. I could go.
Sir, listen to me very carefully. I have approximately 25 more people to go through their cases. And if you want to read that plea form, you are welcome to stand to the back wall and read it. It has all the rights on it. If you do not want to read the plea form, if you want to dispute the reading of the plea form, then I will enter a not guilty plea, and your attorney can schedule you for a hearing at a future date and time.
Okay, listen, that's not the question. That's that, she's saying all the rights we went over back there. This is what the plea form, she's asking if you read the plea form, and understand the rights you have.
Yes.
Okay, I need to move on. He can read that plea form if he wants to.
That's what I was explaining.
Well, have him step to the back wall and read the plea form. And the other man seems like he's finished reading his plea form.
You just said not to go back to the store, right, Miss?
Okay, Mr. Grant Sutton.
You want to get in trouble again?
Yes, Mr. Grant Sutton, we don't want you back there, all right? Let's talk about the plea form now. Have you had a chance to read the plea form, Mr. Grant Sutton?
Yes, ma'am, I have.
Sir, do you understand you're giving up the rights on this plea form by entering a plea of no contest?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine this afternoon?
Oh, ma'am.
Do you understand that a conviction on this case will subject you to being deported, or these two cases will subject you to being deported if you're not a U.S. citizen?
Yes, ma'am.
Sir, I've reviewed both files, and I find that there is a sufficient factual basis to accept both pleas and that you are alert and that you are intelligent. As to case number 2022 MM 5332AO, the court will adjudicate you guilty. How many days' time served on that case?
2 days.
Order 2 days with 2 days credit for time served, in order that you not return to 2655 South Kirkman Road. You must further pay mandatory court costs as to that case. As to case number 2022 MM 3860, the court will adjudicate you guilty and order credit for time served. How much time?
20 days.
In the amount of 20 days, and order that you not return to 3250 Bruton Boulevard.
What you said, Miss?
That I am giving you credit for time served for 20 days and ordering you to not return to 3250 Bruton Boulevard.
So you let me out today?
As to these cases, these two cases, I am going to order your release.
Okay.
There are some more, sir, that I need to order. I am ordering mandatory court costs on that case as well, and costs of investigation to the Orlando Police Department in the amount of $58.28. The monies that I am ordering must be paid to the clerk of courts within 364 days of today's date. If you are unable to make the payments that I'm ordering, then you must request an extension of time from the clerk of courts. Do you have any questions? Is that a no? All right, then you have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you. Both sentences were concurrent, Madam. Who is next? Charles Lamar Lewis? Mr. Lewis? The court finds probable cause in your case for trespass after a warning, and I am setting a bond of $250 in your case, and ordering that you have no contact with the victim and not return to the location where this incident occurred.
Your Honor, the offer from the state was an adjudication, credit time served, no return to 398 Amelia Street. Mr. Lewis would like to accept and enter a plea of no contest.
All right, that's acceptable. Mr. Lewis, have you had a chance to read your plea form? All right, may I have the plea form? Thank you, Ms. George. Mr. Lewis, sir, is this your signature here at the bottom of this document? Did you read this document in its entirety?
Yes, ma'am.
Did you have any questions about anything contained on this document?
Ma'am.
Do you understand you're giving up all the rights on the document by entering your plea of no contest? And are you under the influence of any alcohol or drugs or medicine at this time? All right, there's a sufficient factual basis. You're alert, you're intelligent. One last question, sir, I forgot to ask you. Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen? All right, you are alert and intelligent, and there is a sufficient factual basis. I will adjudicate you guilty. Order 2 days, is that the amount?
1 day, Your Honor.
1 day with credit for 1 day time served, in order that you not return to 398
Yes, Your Honor, 398.
Amelia Street, Orlando, Florida. You must also pay mandatory court costs in this case within 364 days of your release. I am ordering your release as to this charge. Do you have any questions? You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir. You may exit.
Thank you.
Jude Carthy Marcano.
Your Honor, Mr. LaRoche is ready for his plea.
Yes,
May
no
I see the plea
contest.
form? May I see the plea form? All right, Mr. LaRoche. Sir, is this your signature here at the bottom of this plea form?
Yes,
And have you had an opportunity to read this document?
yes,
Do you understand that by entering your plea of no contest, you're giving up all the rights on the front of the plea form?
yes,
So are you under the influence of any alcohol, drugs, or medicine that would affect your thinking?
no,
You understand a conviction on this case will subject you to being deported if you're not a U.S. citizen?
yes,
The court finds there is a sufficient factual basis, and you are alert, you are intelligent, you're adjudicated guilty. How much time served?
1 day.
You ordered 1 day in jail with credit for the day you served in order to not return to the Orlando International Airport without a valid ticket. Further, sir, the court is ordering that you pay mandatory court costs in this case through the clerk of court's payment program within 364 days of today's date. If you need an extension of time to make the payments, you must request that through the clerk of courts. Do you have any questions?
So I go to the clerk of courts downtown, they'll tell me how much I need to pay?
Yes, sir. All right, you have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir.
And you were taking no action on the out on bond, Your Honor?
Yes, no action on out on bond case. Okay. Jude Carthy Marcano. Mr. Marcano, the court finds probable cause in your case for count 1, possession of cocaine. Bond stays at 1,000, and count 2, possession of paraphernalia. Bond stays at 500. Thank you, sir. Daquan Devron Martinez. Mr. Martinez bonded per the jail staff. John Nettles. Mental health.
Your Honor, I will waive. He's in comp proceedings in both of his out on bond cases, so I'd ask that you take no action.
All right, I will do that. And as to the new law, the court does find probable cause for trespass, and bond is set at $250. No action on the out on bond cases.
Your Honor, I ask for no return.
The court is ordering no return and no contact with the victim. Jose Ortiz Concepcion. Mr. Ortiz, the court actually, you were picked up for failure to appear on violation of probation status, and bond stays at no bond in your case. Thank you, sir. Akima Burchett Sandio. Sandio? All right, as to your case, the court finds probable cause as to count 1, fleeing and attempting to elude. A bond is set in an amount of $2,000. Count 2, neglect of a child. Bond is set in the amount of $1,000. And reckless driving, count 3, bond is, the court is ordering a reduced bond of $100 as to that count. Count 1 was 2,000. count 2, 1,000, count 1, 100. State, do you want me to enter any other orders regarding the children?
If she could comply with any DCF plan, Your Honor.
If the DCF enters any orders, ma'am, or a plan in your case, you must comply with it, and that is also a condition of your bond. Do you understand? All right, thank you, ma'am. You're excused. Theodore Earl Sherrod. Sherrod, you were picked up for failure to appear. Bond will stay at $500 in your case. Thank you, sir. Tamiko Smith.
Oh, I didn't.
Tamiko
Your Honor.
Shite Smith.
He actually had an offer, because mine's are
Tamiko Smith.
Sherrod, they're,
Oh, Sherrod,
Mhm.
Theodore Sherrod.
Yes, it's just
The
mine.
resisting case, the failure to appear.
yes, Your Honor.
What's the offer?
Adjudication credit time served.
All right.
Order.
Okay, are you able to stipulate to a factual basis? I haven't had a chance to
Yes, Your Honor.
review that.
Stipulate. Thank you.
And how much time served does Sherrod have?
Yes, 4 days.
4 days? Okay. Has Sherrod had a chance to read that plea form? If not, he can step to the back wall and read it.
He has, Your Honor.
Okay.
And he would like to accept the state's offer and answer plea of no contest.
Mr. Sherrod, is this your signature here at the bottom of this plea form, sir? Did you read this document in its entirety, sir, before you signed it? Sir, did you understand that by entering a plea of no contest, you're giving up all the rights on the document?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine that would affect your thinking? All right, the counsel, you're stipulating that there's a factual basis to accept the
Yes,
plea? All right, I will accept your plea, based on stipulation of counsel. There's a sufficient factual basis, and you are alert, sir, you are intelligent. I will adjudicate you guilty and order 4 days with credit for the 4 days you have served in this case. Further, sir, I am ordering all mandatory court costs, which you must pay within 364 days of your release. I am ordering your release as to this charge. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Any questions? I couldn't hear him.
My question was that also to the failure to appear.
Yes, sir. This is the case involving the failure to appear. Thank you, sir. Tamiko Smith. You have 3 cases. Each of them are failure to appear. As to the child abuse, bond will stay at no bond. As to the failure to appear on the burglary case, bond will stay at no bond. As to the failure to appear on the trespass, bond will stay at $500.
Your Honor.
Yes.
The warrant, I think it stated $500 or mental health PTR. Did you want to keep the mental health PTR?
Yes.
Okay.
Yes. The court is ordering the $500 bond or mental health pretrial release. And I'll also add a condition of no return on that charge and the burglary charge. Latosha Chanel Stewart. The court finds probable cause in your case for trespass after warning.
Your Honor,
Yes, ma'am.
there was an offer to resolve her case, Ms. Stewart's case. Can she have a moment to review the plea form?
Yes, ma'am. Ma'am, I'm going to pass your case to give you a chance to review the plea form. Dwayne Summers. In your case, the court finds probable cause for the charge of trespass after a warning.
I'm gonna go ahead and take care of them today, too.
If, is there a plea offer in Dwayne Summers' 2 counts?
There is, Your Honor. It's showing he's on probation.
No, I do not.
Oh, he's on parole? You're on parole.
No, I'm not. I just killed.
Hold on a moment. Mr. Summers.
8 days down here. All right, go ahead.
Mr. Summers, give me 1 moment. So I am finding probable cause for the trespass charge, and I'm setting a bond of $250. I am finding probable cause for a resisting charge, and I'm setting the bond is staying at
I can't plead out to them.
that bond stays at $500. And I am ordering you to have no contact with the victim and not return to the location where this incident occurred. No, sir. Based on the public defender, it could potentially impact another case that you're on probation. No, yeah, no action on out on bond. Yes, ma'am. Do you want me to give you that back? There you go. Latosha, okay, we're waiting on that one. Shamari Tarika Thomas. Did I just hear somebody say something?
I think she just stated her name, Your Honor.
Okay, so are you Shamari Tarika Thomas?
Shamaray Tyreka Thomas.
Oh, Ms. Thomas, the court does find probable cause in your case for possession of cocaine, and bond stays at $1,000, and possession of paraphernalia, bond is set at $100. Thank you, ma'am. Jason Throckmorton.
And I will waive the appearance, Your Honor.
He has two cases, the out on bond cases, that I had intended to revoke the ROR and order no bond. Now, I have to be totally transparent. I could not fully read the case numbers, and the part that I couldn't read was the letters that come at the end. So I didn't look them up.
It's AO on both.
On both of them?
Yes, ma'am.
All right. So no need for me to look them up at this point in time if the state can confirm whether the state has not filed charges on the first case, the 3050 AO case.
No, Your Honor, formal charges have been filed. Pretrial is set for September 13th.
All right. So the court, I am revoking the ROR on that case, Ms. George.
Yes, Your Honor.
And I am ordering no bond.
Yes, Your Honor.
Now, as to the other case, so in that case, both the AO part and whether it was 0947 or 6947, I couldn't make it out.
It's 6947.
All right.
He was arrested June 14th, and formal charges have not been filed.
All right, so I will not take any action on that case, 6947. The court does find probable cause for burglary of a structure, bond stays at $3,500. Defrauding or an establishment of food or lodging, bond stays at $100, and trespass after warning, bond stays at $100. The court's ordering no return and no contact with the victim.
Ms. Stewart is ready whenever you are.
Why was he not present?
Refused.
Refused.
All right, I'm ready on Ms. Stewart. Latosha Chanel Stewart.
Yes, Your Honor. The offer from the state to resolve her case in 2020 MM 5346 AO is an adjudication of guilt, credit, time served, no return to 1200 West Colonial Drive, and court costs. Ms. Stewart would like to accept and enter a plea of no contest.
Very well. Ms. Stewart, ma'am, is this your signature on this document that's being handed to me right now?
Yes, ma'am.
And did you read this document, this plea form in its entirety?
Yes.
Ma'am, are you under the influence of any alcohol or drugs or medicine?
No.
Do you understand that by entering your plea of no contest, you're giving up all the rights on the plea form?
Yes.
Do you understand a conviction on this case will subject you to being deported if you're not a U.S. citizen?
Yes.
There's a sufficient factual basis. You're alert, you're intelligent. I'll adjudicate you guilty. How much time, sir?
2 days.
Order 2 days in jail with credit for the 2 days you have served, and order you not to return to 1200 West Colonial Drive, Orlando, Florida. Further, I am ordering you to pay mandatory court costs in this case within 364 days of your release from incarceration, and I am ordering your release as to this charge. Do you have any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you. Carmen Elizabeth Vargas, you're picked up for failure to appear, and bond will stay set at $2,000. Thank you. Sor Angel Velez. Sir Angel Velez. Mr. Velez? Sir, the court finds probable cause in your case for trespass on a structure or conveyance, and bond is set at $250.
And Your Honor, the offer, Mr. Velez's case is an adjudication of guilt, credit time served, no return to 138 East Gore Street. And he would like to accept and enter a plea of no contest.
Thank you. May I have a plea form? Mr. Velez, is this your signature here at the bottom of this plea form?
Yes, ma'am.
And did you read this document in its entirety, sir, before you signed it?
Yes, ma'am.
Do you understand that by entering the plea of no contest, you're giving up the rights on the form?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine that would affect your thinking today?
No, ma'am.
Do you understand a conviction on this case will subject you to being deported if you're not a U.S. citizen?
Yes.
There is a sufficient factual basis to accept your plea. You are alert, you're intelligent. I will adjudicate you guilty. Time served.
2 days.
Order 2 days with credit for 2 days you've already served. And I will order you not to return to 138 East Gore Street, Orlando, Florida. You must further pay all mandatory court costs associated with this charge within 364 days of your release, and I am ordering your release as to this charge. Do you have any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir. Keith Thomas Watkins. Keith Watkins? All right, sir. The court does find probable cause in your case for disorderly conduct. I'll order a release on recognizance as to this charge. Kishasha Williams.
Yes, Your Honor.
The court finds probable cause in your case for burglary of a dwelling, and bond stays at $5,000. The court is ordering you to have no contact with the victim and not to return to the location where this incident occurred. And I've appointed the public defender. I believe there may be some previous cases where there were some competency issues that are pending. Ms. Public Defender?
Yes, Your Honor.
All right.
Your Honor, there's more than one case.
Oh, yes, that's right. As to the second case, burglary of a dwelling, I also find probable cause. And also that bond stays set at $5,000. And again, Ms. Public Defender, competency issues need to be addressed.
And no return, Your Honor?
And the order of no return is imposed. Yes, ma'am.
Hey, I got a question I want to ask.
I want you to ask the public defender, and she will inform me if there's questions that need to be brought to my attention.
Each time I go to the courthouse, I can never seem to get my uniform. I'm a sheriff's officer deputy, not to mention a United States judge, capital judge. I was over at my house the other day.
So, sir, today's initial appearance hearing is not the time to bring those matters to the court's attention. However, the public defender will let you know when it will be appropriate to bring any of those matters to the court's attention. Your lawyer will let you know.
The house I was in was my own house.
And to confirm, Your Honor, no action on the.
No action on the out on bond at all, no action. Silas Emerald Willie.
Yes.
The court finds probable cause in your case for burglary of an unoccupied dwelling, and bond stays at $5,000. You're ordered to have no contact with the victim and not return to the location where this incident occurred. Thank you, sir. Jeffrey Allen Weisinger.
He refused, Your Honor.
He has 2 cases. Is the public defender waiving his appearance?
Yes, Your Honor.
As to the first case, the court did find probable cause for possession of cocaine, and bond stays at $1,000. As to the second case, the court finds probable cause for driving on a suspended license as a habitual traffic offender. Bond stays at $2,500, and resisting without violence, count 2, bond stays at $100. That is the end of my list. Yes, I did. Okay, what's that? Oh, let me look. You want me to do it? Okay. All right. Where do I do the RO?
Just reduce it to RO.
Okay, but then I want to put C, where we gonna write it at?
At the bottom of the second page, right?
Okay, C, second page.
Yes. The last guy, he what, refused?
Yes.
Okay, I'm sorry, I was trying to.
Where am I writing it at? Down here?
Yes, that was from downstairs, she said, yeah.
That was the date of it?
Yes, ma'am.
Bye-bye.